Can I start with an apology for coming into court late? We weren't twiddling our thumbs, I promise you, but trying to get on top of the material, for which thank you very much. Thank you also very much for the list of references, which has been extremely helpful. Mr. Gupta, before we hear from you, just, I think most efficiently, just to ask Mr. Hames or Mr. Gratian whether they would like to add anything in the light of the material.
Not at this stage.
No, nothing? Mr. Gratian, you were already on top of it before you stood up, I think.
Yes.
Anything you'd like to add?
No.
No.
Thank you very much.
All right. Then, Mr. Gupta, thank you.
Yes, Your Ladyship, thank you. I, together with my learned junior, Mr. Little, obviously represent the father in this matter. And you'll find, Your Ladyships and my Lord will find our scheduled submissions at page 44 in the bundle.
Yes.
And the aim of those submissions, obviously, is to make sure that oral submissions supplement those submissions rather than the other way around.
Yes.
I said I'd hopefully be about 45 minutes, subject to answering any questions that Your Ladyships and my Lord have. I just want to start with a couple of probably quite obvious points to the court, but they're worthy of repetition. And that is the initial policy approach which the court has to adopt in a Hague case. So if the court looks at paragraph 104 of our submissions.
Mm-hmm. Yes.
Which is at electronic page 66, 64, printed page.
Yes.
I'd invite the court to read that when you can. But essentially, it's this. The welfare jurisdiction, of course, is in America. And the court below, the president of the Family Division, was dealing with an application under the 1980 Hague Convention, which is very limited in its jurisdictional scope, concerning whether the children should be returned to that country or not, to the country of competent jurisdiction. And normally, in these kinds of cases, the country of competent jurisdiction hasn't really made any major welfare decisions until the children have returned. Mm. And because this case has been going on for some time, that is not what happened in this case, obviously. Yep. And so Judge Rashid not only seems to have got married during the course of the proceedings, but also made a welfare-based decision. And so I'll ask the court, with great respect to this court and this jurisdiction, of course, to be very careful about what the parameters are as to its jurisdiction and the jurisdiction of the president of the court below. Yes, of course, it can consider a soft landing, it can consider protective measures. But when it comes to which parent these children should be living with on an interim basis, contact and other welfare-based decisions, that's to be left to the judge in member state A, if I can put it that way.
No, understood.
And that's what's happened in this case. However, she's got about making a decision, and the court will be looking at the transcripts and the various vignettes that we've pulled out on behalf of the father and my learned friends have pulled out. I have to ask, why is the court doing that? Why are you looking at transcripts about what happened? Surely you should be looking really at the order that was made by the learned judge in America and seeing whether or not that causes a fundamental change to the decision of the president in the Hague decision. And yes, he did have that in front of him, and I'll take your ladyships and my lord to the passages in his extempore judgment where he obviously factored into his consideration the change of approach that seems to have been adopted by the American judge, if I can call her that, rather than the English judge, the president, when he was ordering a return. There's a difference of approach, a difference of philosophy, my lord, Lord Justice Jackson said, but there's a difference of jurisdiction here. And the other, obviously, policy point that comes front and centre is the jurisdiction of this court to set aside its own decision under a Hague Convention when the Hague Convention orders have been made. And all one has to look at in that respect for my submission is the beginning of the authorities bundle, the Family Procedure Rules 12.52a and Practice Direction 12F. And if I could just ask the court to turn that up, page 5 of
Do
the
we need to
authorities
turn it
bundle.
up? I suspect.
Probably know it's
My
off by
lady and my
heart.
lord know it off by heart.
2 out of 3
I don't
know
know
it.
it off by heart, but I have read it very recently.
Well, in my submission, it is a very high bar, and other examples are mistake, fraud,
Yeah.
material non-disclosure, etc. When one's looking at setting aside, and consequently, the word fundamental is with a capital F.
Yes.
Change. To say otherwise would, from a policy perspective, cause real difficulties with Hague Convention cases that happen in this jurisdiction and indeed in other countries who look to the English jurisprudence when it comes to deciding cases under the 1980 Hague Convention. And of course, the whole process is summary, swift. Children either returned or not returned. But then to add this layer of, well, let's have another look at that. Let's set that order aside. In my submission, the policy has to be that really, as per Lord Justice Morland has set out in Re W and Re B, which of course you have in the authorities bundle at page 100, where he's repeated what he said in Re W. He said it in Re B, of course, that it's a high bar. Fundamental change of circumstances. And so I'd ask the court to, and it may be a very simplistic approach, and apologies for that, to look at the actual wording of the order of 2024. And of course, and it's the syntax really. If you look at where the learned judge orders the return at paragraph 9.
Sorry, are we looking at the November order?
November order, yes.
Oh, are we? Right.
Beg your pardon, November.
No, that's fine. Yes.
Then you'll see my point about syntax. Because obviously the court is saying that other suitable third parties should be available. And if they're not available, it should be foster care. But in any event, it's added there. That not placed in his care pending the hearing referred to paragraph 8 above, but to be placed in foster care in the absence of any other suitable third party being available. And of course, third party, it doesn't say...
Sorry, where are you reading from?
This is page 98 electronic, top of the page, paragraph 9, page 96.
Yes.
That's the original order.
Yeah.
It doesn't say a third party from the mother's family, or their mother has always been given the opportunity to find somebody. It says a third party being available, and my client has provided one now. And as my Lady Justice King pointed out, in the immigration papers, it's clearly set out that the mother said that she doesn't have any issues, or didn't have any issues with the father's family, extended family, prior to the departure. I can turn up the page reference to that in due course.
When was the paternal grandmother first put forward?
Recently, this year, before the President at the set-aside hearing.
So
Because
July.
if we go back to
Yes.
the,
That's my understanding.
the hearing in Delaware, she wasn't put forward.
No.
So are we to deduce that she was put forward then between the July hearing, the May hearing and the July hearing, or the May hearing and the hearing in June before the President?
Between the May hearing and the June hearing.
Right, so just as soon as the hearing in America had been dealt with, one of the parents, your client, in
Yes.
fact, produces a third party, even though the American judge had been looking for a third party, but wasn't given one.
Wasn't given one at that stage, as far as I'm aware, but of course, we were waiting.
We've seen the transcript.
Yes, indeed.
The judge was clearly interested
Yes.
in the idea. She said, don't these people have family and friends?
Yes, indeed. Yes.
So
But my understanding is...
After the May hearing, the grandmother is first provided. Thank you.
And my understanding is my client has been waiting, and indeed the court, the president was waiting for the mother to put somebody forward from her family. Because that's the first stage is...
On the basis that that would be a softer landing
Yes,
than a paternal relative.
indeed.
What is your syntactical point?
The
you say that's-
syntactical point
Yes.
is that because it's phrased in the absence of, it should actually be the other way around, which is essentially placed in with a suitable third party, and if they're not available, foster care. Either way, it was envisaged in my respectful submission that foster care was the last resort, and that third party surely was the second option if the mother was arrested. First option being, of course, children remaining in the mother's care. And if one looks at the other order, which of course is the US order,
So you say in November 24, situation was ideally children in mother's care, secondly, third party, thirdly, foster care.
yes.
Right.
But it didn't stipulate, as I said earlier on, sorry to repeat myself, it didn't say a third party from mother's family, but that's what was envisaged.
And if that's right, we jump ahead, why isn't it the complete opposite under the American order? It's father first. then-
It is
then-
indeed
then-
father first,
then-
yes.
Well, and then there isn't a third party under America.
Well, no, but father, if one looks at page 310, electronic page 307, Rashid's order, Judge Rashid's order, of course, it's mandatory. Father shall allow children to be temporarily cared for by a known family member. It doesn't say which family member. It could be the mother. It doesn't say excluding the mother. The father, of course, can place, as the children will be in his overall custody.
I have to say, I find that a pretty I mean, as a matter of grammar, I suppose so, but as a matter of contextual interpretation, isn't that a fanciful submission?
My submission, no, because of what was said in the actual transcript, which we sent up our relevant passages. Where, if I can just turn it up, sorry.
You might be at page 44 of the transcript, perhaps, line 2 and onwards. I'm looking at the separate transcript, Mr.
No, it's ridiculous. If you look at
Father wants to waive his right to exercise
Yes.
sole physical custody under the current temporary order and say, no, I want them to go with the mother's family member or with my family member, then he can do that.
Yes, it's entirely,
No reason why I'm going to order that the children go to foster care.
But your suggestion is that when you construe the order as a whole, as we must, you can include as a matter of contractual interpretation, because that known family member incorporates mother.
yes,
And you say that when you look at E and F.
yes. Because, of course, if he chooses to place the children somewhere else, then contact would have to take place. And it doesn't exclude, the order doesn't exclude the children from being placed with
Just,
their mother under the father's
is there
aegis.
anywhere else in the transcript, apart from the section that my lady has referred to, where you can see anything in the hearing or in the judgment of the American judge that she contemplated the father giving the children to temporary care, for temporary care to the mother?
I have a reference, page 64,
Thank you.
lines 9 to 25, which
Thank you very
we've
much.
pulled out in our
64,
documents.
9, 2025.
where the judge says, do I agree with that unification will be necessary at some point, 100%. And whether or not there would be an agreement to that, I can't imagine one reason why I would not allow it. And the father's American lawyer, Mr. Huffman, says, well, my client would do it. He's has sole legal custody to the kids, so he would do it voluntarily. And that's reunification, of course, of children with their mother.
But that's what Mr. Huffman was saying.
Yes.
When we look at the order and we look at the totality of the transcript, it's clear, isn't it, that the judge was of the view, well, the way she puts it is, common sense is telling me that when she hits customs, the warrant will blare like a siren and they'll take her into custody right there.
Yes.
So the judge wasn't, by this D, thinking, oh, well, family member could include mother as well.
She probably wasn't in reality, because she was saying that.
Because she was, and
but-
further on she says, I'm not going to go to the mother.
Indeed, but having said that, Your Ladyship, she doesn't say, well, obviously a lot of these are words that are missing. The words that are missing are excluding mother. But it's done on the premise that the mother will be arrested.
I'm having some difficulty with this, Mr. Gupta. I was
Yes.
trying to make myself a list of what each of the judges thought that they were approving.
Yes.
And I think we have, I'm talking about for the period immediately after the children arriving in America, before a judicial decision. And I think we have three possibilities from the point of view of the English court that made the return in order of preference. Firstly, to the mother.
Yes.
Secondly, to a third-party family member on either side.
On either side, yes.
And thirdly, into foster care. So those three matters were in the President's mind. What was excluded by the President for that period? Not the father.
And he accepts that.
Yes, well, I'm just checking it. I mean,
Yes.
At the moment, I'm just trying to look at this in a neutral way to see
Yes.
what was involved. I think that summarises what was going on here. If one then turns to the decision of the Delaware judge, at the top of the list is the father.
Yes.
The second possibility is family third-party care on either side. And there the list ends.
There the list ends because the learned judge was assuming
because
mother will be arrested.
Judge was not prepared to contemplate, for reasons which one might perfectly understand, foster care. And similarly, the judge was not at any price, as I read it, prepared to contemplate placement with the mother, if for no better reason than that she clearly regarded her as being an active flight risk. And so, in the United States, mother, third party, foster care. United Kingdom, mother, third party, foster care. And in the United States, father or third party foster care. The only overlap I can see in that is third party foster care. And the difficulty that we discussed a moment ago was the fact that nobody put forward third party foster care to the judge. And if they had done, again, we might not be here.
Yes.
But so there appears to have been a complete lack of a meeting of minds between the two systems. This would be a difficult case if it involved two parties living in the same borough. But as it is, we've got two systems operating at a distance, but a far greater distance than perhaps there ought to have been.
Well, yes, but in the absence of options coming from the mother, the father, as you heard, during the summer of this year, produces his mother, and that meets the criteria for both courts. And that's what the learned judge, the president of the Fan Division, looked at in detail when he considered this option.
Why, if we compare the pre and post US decision world, the President's decision was mother first, et cetera, not the father.
Yes.
US decision, father, not the mother. Why is that not a fundamental change of circumstance?
Because on the ground, the reality is,
Right.
practically, the father is saying, I will not take up, I will not enforce that order, I will not take up the physical custody of these children.
And
I
we get
will.
that from where?
Paragraph 17 of the judgment that's the subject of this appeal, page 169, electronically of the bundle, 158I. Father's position is now he puts forward his mother, the paternal grandmother, as the potential temporary care of the children, if they come back to America. He's accepting that they should not be placed directly in his care, pending any application for a review hearing.
And if he does that, will he be in breach of the American order?
No,
Because
the American order gives him effectively care and control, custody. So yes, he could be considered to be somebody who has the potential to breach that, but in Morrison's mission, he's not shown to have breached anything.
But is
in
he
the
breaching
past.
it or not? He has to take immediate, temporary sole, legal and physical custody. That's what the order says. He can allow them temporarily to go somewhere else on condition,
Yes,
yeah?
which he accepts on the evidence.
But
that he's
what
seen.
if the children are happy? Under the order, does he have power to put them temporarily with a known family member? Would he be in breach of the order if he did that?
It's a matter for his opinion. If, in his opinion, if he determines that the children are not experiencing,
Well, what if he determines they're very happy?
yes,
What is he able to do under this order?
he's able to exercise his rights of custody and his right to custody of the children, as enshrined by this order.
But he's ordered to take sole physical custody, with the exception in D.
Yes.
So
And
how could he not be in breach of the order? If the condition wasn't met, under this order, he has no option, does he? He has to have sole legal and physical custody.
Yes, but his instructions and his position is, as it was to the President in the division below, he accepts that these children are experiencing and will experience extreme emotional or mental health issues, and so they should be placed with a third party, namely his mother.
So are we to effectively ignore the wording of the order in America and proceed on the basis of what the father says he will nevertheless do?
Master's mission, not to ignore it, but it's a matter of how it is enforced and which parts of it the father, in having custody of these children, what he decides, what he determines should take place. And he is saying that he has already determined that the children are experiencing extreme emotional or mental health issues, and they will do so in his custody, and he will be placing them in his mother's care. And he's shown willing and able to do everything that he can within his power, as he promised to the court last year in November.
I may be misremembering, but did Mr. Hames say that there had been a change of position on the part of the father after the American order?
I think Mr. Milo from the Gratian King's
forgive
Counsel
me.
said there was a change of position before Judge Rashid, before this order. I don't know if that's what your ladyship's referring to,
Right,
but
okay.
I couldn't really see that in the transcript. I couldn't see him sort of reneging.
Having read the transcripts,
Yes.
I'm sure with great respect to no doubt these very sophisticated, able lawyers, there did appear to be a little bit of grandstanding going on.
Surely not.
Because at the end of the day, what the fundamental submission on behalf of the father was that he was trying to honour the order.
Indeed,
So I think one could be forgiven perhaps for
yes.
seeing that it got a little heated perhaps.
So, picking up from that, your ladyship, to try and honour the President's order, he goes to the American court. He is given an order denying his application and ends up with an order which he then refers back to the President of the family and says, what do I do now? are now mummified in international red tape here, put it one way. And so that's why the then judge, president, goes through that decision in this order. And having been presented with the option of the paternal grandmother for the first time, seizes on that and said, well, that's not really a fundamental change, as long as you follow this through.
Have we got a copy in the bundle of the application that the father made after the American order was made?
The application to bring it back to
Yeah.
the president, I don't believe we have that in this
See that?
core bundle, but we can get that to the courts.
I think it'd be useful so we could just see how he was
As pictured.
describing the international red tape.
Yes. He has a welfare-based decision that he didn't seek in Member State A. He goes back to Member State B and says, well, now what do I do to enforce this order? And of course, that opens up the application to set aside by the respondent mother.
Could I ask you this? Can you detect in the transcript any awareness on the part of the American judge of the judgment that was given in June 2024 by the President and the UTJ?
Or November, for that matter.
You
or
mean-
indeed November, but the main judgment setting out the history and the reason for the concerns and the reason for the protective measures. I mean, I'm sure the judge in Delaware was very busy, but it almost seems as if that court was operating without having absorbed what this court had said, this country's court had said. It appears that it was an exhibit to documents that had been filed, but so far as I could tell, there's no reference to it at all. The second point, while I've interrupted you, is this. There are a number of statements by the judge who is charged with this case in the United States, making it, as far as one can tell, perfectly clear that she's not going to allow these children to remain with their mother on any terms, either before or after an initial hearing. Does that create a problem for the basis on which the President made his order? Because before reading this, I'd assumed the matter was going forward in the normal way, namely that there will be an initial hearing and the judge will make an open-ended decision about what is then going to happen. It's not looking open-ended on the basis of what we read.
In answer to your first question, Your Lordship, if you look at page 14 from Mr. Huffman,
Yeah, it starts actually, bottom of page 9. Mr. Huffman says, in essence, what we're trying to do is effectuate the agreement that was reached between the parties. Reference to the English proceedings, and then page
14,
14. Yeah.
Hague Convention litigation, soft landing.
Yes, I was specifically referring to the fact that the English court had produced a very
Yes, I can't see that.
substantial judgment
Yes.
about why it took the position that it did. But we have the American court, which, not saying it's right or wrong, which doesn't see the least reason why the children shouldn't be placed into their father's care at the airport.
Yes.
But there just doesn't appear to be any meeting of minds.
And that's why it may be in your options that you provided, Your Lordship, earlier on, before the short adjournment, that it may, this case may be crying out for an adjournment with reasons to see whether or not issues can be dealt with.
You mean this appeal?
This appeal, yes.
Page 14, that same page, it looks as if all the learned judge in America had was a one-page document. Is that different?
No, I think the position is that, if I use the word buried, I don't mean it disrespectfully, but the American judge had a clip of papers which included the President's judgment from July 2024, 24,
that's my
and the FTT judgment. But I mean,
Yes.
these are substantial judgments
Yes.
agreed and absorbed.
I think the one-page document, Mr.
the
Gupta,
agreement.
was the handwritten document,
Yes.
presumably drafted by the father, saying what he wanted the court to do
Yes, yes.
Oh, I see.
Yes.
at the beginning of the proceedings.
It's this
bundles.
page at the,
That's
at
it.
the very
That's it.
front.
Thank
that
you.
you've
So
got on your screen.
where is the learned judge in America taken at any stage to the full judgments in the course of...
I haven't seen that. And of course, that decision of Judge Rashid wasn't appealed by either party,
Yes.
and so stands at the present moment in time.
Well, one sees, just for our note, we see that the June 2024 judgment appears at page A24 of
Yeah.
the US proceedings bundle clip, and it's followed then by the...
My lord's been kind to me because he's ahead of me.
Yes.
So,
Well,
Kind to me, I think. Yes.
yes, I see.
Both there.
but I'm not in any, I wouldn't wish it to be understood in any sense of criticism of the judge in New York, but that was there. But to
Yes.
read the transcript, one wouldn't know it. Is that, I was asking,
Yes.
and Mr. Huffman did refer to the fact that it was there. I think referred to it as the Hague report.
Yes. Well, 2 points that flow from that. Of course, mother was represented, and no doubt counsel on that occasion could have raised these points. Have you read these passages from the judgment? Second point is, anecdotally, obviously, it's often an issue when you have cross-jurisdiction, you have proceedings going on in two different countries, and one country doesn't actually look into a detailed
But
judgment.
isn't
But
it
Mr.
a
Gupta-
principle of the convention? Sorry, that I mean, each country is signed up to it, and
Yes.
and the state authorities, in this case the judges, are enjoined to collaborate to make sure
Yes.
the convention works smoothly. But in this case, just objectively, it seems that in some ways the left hand didn't know what the right hand was doing.
Not in detail, if I can put it that way.
And Mr. Gupta,
Yes.
picking up what my Lord Justice Peter Jackson said about any connection or reference to the original decision by the President at page 52,
52.
the judge says, I think we're getting a little far out into the weeds here. This court cannot make any determination as to mother's character or intent or actions in the UK. No evidence before me of that, whereas, of course,
She did.
he did.
Yes.
Internal page, what?
52, starting at line 1.
But
It's 52 internal, A1, A200,
Thank you.
top of the page.
Thank you.
And of course, turning to the second point that your lordship mentioned, expecting that as normally to proceed in the normal way, doesn't look like that's going to happen, bearing in mind what's happened, what this transcript provides. But of course, the matter would then be referred back to the learned judge on an emergency basis. And no doubt this court, any order of this court, can indicate certain documents that it's inviting the welfare judge, if I can put it that way, to read before she makes any further decisions about custody and care, etc. So that could be repaired, the concern about what the future steps are. And of course, an application, if matters follow the normal course of events here, if you've got a judge saying things like that, then the application would be surely for them to recuse themselves and for a different judge to take matters over, if it warranted such an application. Because these, of course, are comments that are made by the judge, with the children having been in this jurisdiction for some time. An abduction on the face of it, a criminal abduction on the face of it, and so naturally she's going to possibly show some judicial anger over the issue.
Of course, the judge did give them opportunity to the parties to go back to her if they could agree a person. Because she said at page 54, agree to a person, then this court can do that and out a schedule to a hearing. It's the equivalent of listing.
Yes.
if there is no third party, I mean a family member, then I'm going to order when the children return to the UK, father shall have immediate temporary sole physical custody.
Yes, and
What happened?
I'm afraid parties are in their silos. And the learned judge is left with that decision. That matter doesn't come back in front of her. As I said earlier on, there's no appeal. But she has said, and this is something that was seized on by the learned judge in the court below, the president, that the matter, of course, would return back to her for an emergency hearing. And if I can just turn up the relevant passage, which is page 57, lines 5 to 10.
Sorry, could you give me that reference again, please?
57, lines 5 to 10. So literally, Mr. Huffman will call Chambers and he'll say, the children landed, yes, they're with father. I point out that. Got a call from the airport, we need a hearing, schedule hearing, and they'll get you in like literally ASAP. So what's envisaged is a hearing as soon as possible, obviously, upon return, and the impression one gets is that when she says in her order, right at the end at paragraph 5, which I know my lord and your ladyships have seen, paragraph 5, page 311, once the children are in the father's physical custody, Mr. Huffman shall notify Chambers an emergency hearing was scheduled at which the children should be present and or available for interview. Now, of course, on interview, it being a welfare-based jurisdiction, their views will be ascertained and the court will then look at the matter afresh, one imagines, whatever the learned judge has said concerning the possible route forward. Because, of course, she was thinking the mother will be arrested upon arrival.
I think we get some more help about this at page 216, which is 68, where the judge is again speaking. This may also bear on a question I asked you a moment ago.
Sorry, page
68, 216, line 15. The judge is talking about getting it immediately scheduled as
I'm
immediate,
grateful.
like possibly which is usually within 2 to 3 days immediate.
yes.
And then we come in and we talk more about the psychological trauma. We pick a reunification counsellor and we see where the children are literally going to be laying their head moving forward. So that's the judge's vision.
Yes. But if it was all a done deal, as it were, with regards to her saying, well, these children are never going to be with their mother and custody is going to be with the father throughout, I can't imagine she would be saying these kinds of things.
It was
Yes.
with that in mind that I
Yes, I'm
thought
grateful.
it was
Yes.
necessary to look at that.
Yes. So, and so Rights Commission, the learned American judge, is trying her best in difficult circumstances where the parents are in their silos, as it were, to try and get them to agree a third party a way forward and to bring the matter back to her as soon as possible, once the children have been returned, pursuant to the English Hague Convention order. Maybe she didn't read the decision, well, she obviously didn't read the decision, but she knew there was an order for return. And turning to the judgment, which is the subject of this appeal.
Just before we move away from the
Yes.
transcript, just in fairness to you, page 54, internal A202, just addressing your submission that the third party referred to in the American order could have included the mother. Do you see line 10, if there is no third party, and by third party, I don't mean CYS, I mean a family member that the parties can agree to, then I'm going to order, etc., etc. Do you still say that the reference to family member in paragraph D could include the mother?
Well, it's a family member that the parties can agree to.
Yeah, I mean, technically, but Right, so you do.
Because if one goes back to my client's position, it is, if the mother is arrested, then the children will go into my mother's care. But if she's not arrested, his position was that he was not removing the children from her care. And so with an order that they're in his custody, his care and control, as it were, he could, there's no reason, my suspicion, why he couldn't say, well, that can be the mother temporarily, and then we'll bring it back to court. But that's all done on the basis, of course, that she's not arrested,
Thank you.
which in reality looks like she will be.
Sorry, I interrupted you.
Can I just
look at
tell
the
my
July
back-
25 judgment? President's judgment.
Yes, President's judgment.
Yes.
Thank you.
Yes.
Yes. So, your ladyship asked about where the learned judge actually analysed the order from America.
So what I really meant was where does the president look at the American order and say, does that or does that not amount to a fundamental change in circumstance?
I have to say that he doesn't do it with a subheading and go through it in a fine, in a way that's specific in one paragraph or two paragraphs. But what he does do is, if you read the judgments as a whole, which I know the Court of Appeal will, he deals with it in that way, picking up aspects of it, pointing out the father's response. Of course, it starts from really paragraph 12
Yes.
onwards. He identifies it. She made an order giving temporary sole custody. This is at electronic page 167, 158G. And sets it out as the facts, that are the background facts.
Yes.
And sets out paragraph 14, where the father seeks to vary the terms of this order, this court's orders, so as to fit with the orders that are now being made in the American court, and the mother seeks to set aside. So he sets out the history of it, the applications that flow from it, and in dealing with the applications, with the father's application, paragraph 17, which I've already read part of, father now puts forward puts forward his mother. And the question then is, with that in place, does that result in a fundamental change in circumstance? Paragraph 25,
Yes.
again, is where I pick up the president saying, we now know that it's not possible. He sort of quotes Donald Rumsfeld and starts talking about known knowns. There is still a known unknown, which is, will mother actually be arrested on arrival or not? But it looks likely. We now know the American court has awarded temporary custody, both physical and legal, to the father, and had left it up to him to determine whether children should be placed in the care of any other individual. And paragraph 27, 4 lines down, points to the fact that he's now, father puts forward his mother, whose father's short statement. So he had evidence in front of him from the maternal, paternal grandmother, and then deals with why there is no fundamental change in circumstances in paragraph 29.
Well, your submission at the end of 27 is really that whatever may have happened in the American court, the basis of decision was they weren't going to go to your client, and that still remains the case.
On the ground, yes.
And your argument is the fact that the grandmother came late doesn't change that.
Yes. Because, of course, if he didn't have a third party, that's when we end up in Mark's submission, in a position of potential fundamental change of circumstances. Because if there is no third party, and the father is saying, well, I've got my custody order, I'm now going to seek to enforce it, have the children in my care, that's completely different to what the President felt should happen as a matter of protective measures and soft landing. But that's not what's being put forward by the father.
Because you'd say that there couldn't be any criticism of the father for putting grandmother forward until after the American order, because he'd gone there thinking it was going to be foster care, but hoping that mother would come up with someone.
Yes.
And then it was during the course of the discussions in the transcript that we've now had the opportunity of reading, that it's the judge saying, well, what about the father? You know, why doesn't he can come up with someone, he can decide to place the children with one of his family members.
Yes.
Then makes the order, and father goes away and says, right, well, I'll now make an application to the court in the light of the American order and say, look, judge, that's not worked as planned, but
Yes.
look, here's a third party.
Here's another option.
Here is the other option.
But if I could respectfully remind your ladyship of paragraph 30 in this judgment, page 175, where the learned president again says, so whilst foster carers are no longer a possibility, it remains open to the mother to put forward anyone that she chooses. And in default of that, the paternal grandmother is in readiness to take on the care of the children. And so what one has on the ground, with great respect to the mother, is a process of frustration of the order for return, because it's surely available to her to find somebody who the children know, who's a member of the family or somebody that she can put forward to say, how about this person? But if she does so, of course, knowing that there's no foster care available, then she defeats her objective, which most regrettably is to keep the children in this jurisdiction, having abducted them out. Let's face it. So, and at 31, that's why the learned judge says, and he talks about the pending emergency review hearing in America, the basis is not fundamentally changed. The structure remains the same. And it's
The basic structure being not intolerable for the
Yes.
two children to be in some form of temporary care with another person pending an emergency review.
yes. And page reference in the immigration bundle. When I say the immigration bundle, I mean the supplemental bundle. If I could just turn that up very quickly. It's the, I may have lost it, it's the passage where the mother confirms,
Page 226 of the
thank you very
supplementary
much,
bundle.
mother confirms that she's had no issue with the paternal family up until the removal of the children. So if one looks at the actual reasons why it's being said that these children couldn't be placed with the paternal grandmother, the mother's skeleton submissions, page 78, paragraph 21, the children's skeleton submissions, page 34, paragraph 84. I invite the court to read those. We cannot see with great respect there being a reason why these children can't be in the temporary, 2 or 3 days, temporary care of paternal grandmother. Unless, of course, the mother suddenly comes up with somebody else, somebody who she's putting forward now. If the court refuses the application, the appeal, and she understands that these children are returning, and that the only option is for her to come up now with somebody if she doesn't want the children to go into the paternal grandmother's care. But as I said, those references, effectively, all they're saying is she doesn't really speak much English and they don't really know that well. It doesn't say as far as I could see, that the grandmother has harmed them, will allow them to be harmed, and of course, in my submission, the court should understand that the father will stand by his promises to this court in this jurisdiction the way he has to date.
Could we look at the situation exclusively from the standpoint of the children who are not responsible for the inability of their parents to reach any agreements? What we have here is a situation where the children would be returned into a jurisdiction under the authority of their father against a background of a judge who sees no reason why he should not be looking after them unless that becomes unfeasible. How was the President satisfied that in those circumstances the English court, bearing in mind its responsibility to the children, could be confident that your client would carry out his promises, whether they were in the form of an agreement, whether they were undertakings, because I welcome your help as to what he actually has committed himself to that is in any way legally binding?
Yes, and of course, I add to that, not a member of the 1996 Hague Convention, and so one's relying upon his bona fides to this court. And
Relying on good faith.
his good faith, absolutely. Well, in our respective submissions, we, and Malone Jr. hopefully will turn this off if he finds it, we point out that at no stage in the mother submissions was it said that he would breach his undertakings. But my own friend on behalf of the children, Mr. Hames, King's Counsel, points out that there is that risk. But in my submission, it's a negligible risk. It's not a real risk in this case with this particular individual, with this father. Because of, you've seen, he's been to the American court, he's made his application on a consensual basis, he's asked for the relief that he then didn't get, and then returned back to the English court in a very transparent way, seeking the return of the children in his, and to be placed in his mother's
I understand all of that, but
Yes,
as you rightly emphasised at the beginning, America is the welfare state.
yes,
Right?
yes,
So on your client's case, it will all be resolved in America and the American courts will
Yes.
have charge of that.
yes,
On this basis, arguably, he will be, if he does what he says he wants to, which is to voluntarily give the children up to the mother or the paternal grandmother, he's going to be acting in breach of an American court order.
With great respect, I don't see that. We've had this
Yeah, we have. Okay.
already.
But if that is a tenable view, well, assume for a moment that would be right.
Yes. If he says they're
what
happy
would-
in his mind,
Sorry?
if he says they're happy, if he thinks they're not being,
No. Well, let's just say that he doesn't determine
yes,
that they're experiencing extreme emotional and mental health issues
Yes.
whilst in his custody. But he just hands them over because he's given this promise here. Is it realistic he's going to, if that might be a breach of the American court order, he would do that, would he?
well,
Looking ahead to the future and all the
I'm
attitude
going
of the
to
American
repeat, I'm
courts
going
to
to
that?
repeat myself now, but he already accepts that because of what's happened, these children have been here for 3 years, they haven't seen him for 4 years, that obviously they're not in a position to live with him upon return. That obviously there has to be some interim care with somebody else, with mother if she's not arrested, the third party.
It might appear from the transcript that the judge had no difficulty with placement, for example, with a grandparent.
Yes,
She just wasn't being offered a grandparent.
yes,
But on several occasions, she asked for one.
indeed. And if the matter was returned to the American judge to ask that one question, or 2 or 3 questions that flow from it, then one may end up with an order saying children to be placed in paternal grandmother's care, name, address, etc. Matter to be listed on whatever date, a day or 2 after the physical return of the children to the jurisdiction of America. One will then know, of course, whether mother has actually been arrested or not. But secondly, this court can be reassured that that is the up-to-date order in place. And that's why my fallback position is to adjourn this hearing, but with reasons, if the court feels that it needs further confirmation that the American judge has all the information that she needs to and has actually got the up-to-date information. But my primary position on behalf of my clients, of course, is refuse the appeal and don't set aside the refusal to set aside, but just put in place the order. I gather passports can be obtained from the American embassy and they can be returned. Shall I turn to the hypothetical position?
When you say passports, you mean the children's passports have expired, or?
I think they've expired, but new passports can be obtained. The FBI has them and can say that, or says they just need to turn up to the US embassy. Mother, for her reasons, is reticent in going, but they can always go, maybe with their solicitor, to get their passports. So on a practical level, there's no reason why they physically can't return within the next couple of weeks, knowing that the court ordered their return last year. I think I interrupted your lordship because you were asking about looking at things from the children's perspective, where both parents have failed to come to an understanding about what's going forward. And that's, one can't deny that these children are the victims of international litigation. But the genesis of that is the abduction. It's the wrongful removal. And the predicament that the mother finds herself in, the possibility of criminal proceedings, is something that is a natural consequence of what she's done. And this court, as we pointed out in our respectful submissions, in Kayani and Suleiman, the conjoined criminal appeals, was deprecated such behaviour. Children being brought up hating the other parents. These children are the victims of this.
The hypothetical?
The hypothetical, yes. So we respectfully submit that if you decide to set aside the decision, the question is whether or not, of course, we can just cut to the chase and get on with the Hague decision. One option, of course, would be to remit the matter to the court below, but more time, more evidence, more cost. We respectfully submit the best way is to look at the actual Hague Convention application in the round, understand what the defences would be, which are no doubt child's objections and grave risk of harm, and see whether or not it meets that criteria. I respectfully submit that the court has to bear in mind what my Lord Justice Jackson pointed out, where this is not just a vanilla background. There have been findings or non-findings, not only in the American courts, but also, importantly, in the immigration proceedings. And I think it was Lord Hoffman, in an authority that I can't name, mentioned the binary system. It's either 1 or it's 0. It's either found or it's not found.
B.
Thank you, B. It's either found or it's not found. And it's not been found here. And if you look at page 237 in the supplemental bundle.
Sorry, 237.
237.
Thank you.
Sorry, 239 electronic. 237. Here's just an example of the non-findings, because there are others, and I can give the court paragraph references in a moment. So paragraph 80, overall and after careful assessment of all the evidence before us, we're unable to accept the evidence of A2 and A3 being reliable and thus credible, even on the lower standard. Accordingly, on the lower standard, we do not accept that A2 and A3 have been sexually abused by their father. So it's a non-finding. Paragraph references are 38, 49, 63 to 68, 75 to 80. But of course, there are no doubt others that your ladyships and my lord will look at.
Is this a submission that we ought to simply, if the appeal is allowed, we ought to do what? We ought to just remake the decision, or?
Yes.
Well, I hesitate because your brother judge, Lord Justice Moylan, said, of course, when he granted permission, that we should be prepared to go on to stages 2 and 3
No,
and 4.
I wasn't expressing any view about it. I just wanted to know what options you had. You mentioned remitting, but you weren't very keen on that.
No.
I think you're mentioning at the moment simply dismissing the entire set of proceedings because they could never get over the hurdles.
Yes, that's effectively what I'm saying, is that these defences...
And are those the two options? I think you also mentioned some sort of adjourning
Yes.
as your fallback.
Primary position is, of course, refuse the appeal. Secondary position is, if you have any concerns over what the American judge will do on the ground and what's the situation on the ground, adjourn with reasons, short adjournment to allow the American judge to be contacted and be asked, what are you going to do? And can you give us an updated order, for example, with paternal grandmother named? And then moving on to the hypothetical, if the appeal is granted, and one then looks at whether or not the set aside, the Hague decision should be actually set aside. Sorry, the Hague decision is actually set aside, then one's looking at what should happen concerning the original Hague application.
Well, I'm sorry, I'm thinking as I speak, and probably
Yes.
thinking after I speak, but what I'm imagining you might be saying is that even if we thought that something had gone wrong and the President's decision had to be set aside,
Yes,
we could ourselves consider the application to set aside the original return order and reject it.
yes, yes.
So-
Because, of course,
Is that right? Is that what you're saying?
because one isn't looking at the 2024 orders, which were unsuccessfully appealed. One's now looking at the set-aside decision. And so if it's not set aside, the question is, can the court look afresh at the President's 2025 set-aside process? And I'd invite the court not to set aside those
I think
decisions.
that's the extent of our reach, isn't it?
I think so. Yes.
I think that the most that we could do in that situation would be to remit the question of whether the order should be set aside in the circumstances that
Yes. Well, that's why I have to admit I was slightly confused by page 178 when Lord Justice Moylan granted permission, because it then said party submissions will need to address other matters referred to in paragraph 89 in review to cover the situation in the event of the court appeal, concluding that the President's conclusion was wrong. And that's that four-stage process. So I then started thinking that maybe that's looking again at the set-aside and guided by the court. Morrison's submission should
Well,
be
I
remitted.
think we need to think more carefully than I've been able to do so far as to whether this court's power includes the power to simply dismiss your client's summons,
Yes,
root and branch, and bring the Hague proceedings to an end.
yes,
That's the question that I'm trying to focus on.
yes. In Morrison's submission, I don't believe the court can in this appeal. He having, as I said, the decision, the substantive decision last year and the order in November, having both been unsuccessfully appealed. So the question then is afresh should those decisions be set aside, and that surely would have to be remitted, unless the court finds a swift route to say, hypothetically, if we're wrong on this, then we still would nevertheless have gone on to say that these children should be returned summarily because any...
Or is this paragraph 89 of Re B?
Paragraph 89, Re B.
Of Re B.
Yes.
Have a quick
Just
look at
bear with
that.
me. That's,
Page 83 of the authorities bundle, and
yes.
it's towards the end.
It's at page
Paragraph 8,
103.
page 103.
Yes.
Suggest the process should be applied, this is Lord Justice Moylan, when the court is dealing with an application to set aside. One, will the court decide to permit any reconsideration? If it does, the extent of any further evidence, whether to set aside the existing order. If set aside, the court will redetermine the substantive application.
Yes.
That's the remittal.
I think I'm sure there's a risk of this providing further confusion, but I think the powers of this court extend to anything that the judge himself could have done
Yes.
in that situation, which included, at least theoretically, redetermining the substantive application. But I imagine you would say that that might go too far.
In my estimation, it might go too far, but having said that, hypothetically, if the court wanted to go through that whole process, having granted the appeal, because of the amount of time that's elapsed, and these children is getting older and wanting to deal with the matter, the substantive application, we respectfully submit that is a Hague application, and the defences that are raised, as I said earlier on, that's why I started talking about the immigration decision. It's not done on a vanilla background. It is simply that these findings or non-findings of fact have already been made, that the court has the decisions from the American court as well as the immigration tribunal, first-tier tribunal. None of those were appealed successfully, and so it starts with a factual background and backdrop from which it can look at the potential defences. And if those defences are, there's a grave risk of emotional, sexual abuse, etc. on return, I don't want to minimise it, or that hasn't been found as a fact. So we respectfully submit that those defences don't reach the first stage. Final point on that is objections, children's objections, because of course that would be raised as a defence. And I'd invite the court to look at Re-M, which is the House of Lords decision, I think it was, which is at
This step is the first instance, not on appeal. So we need to get CP 52. My computer has managed to switch itself off,
Okay.
asking for a code that I don't have. Is there a white book in the house? Or is there CPR 52 anywhere?
Yes, I can get it.
Somebody could just get that up on the screen for me, thank you. I'm just looking at the powers of this court.
yes.
It's any-
Because of course 89 is dealing with first instance.
It's any,
Thank you.
it's
Thank you very
anything
much.
the court below could have done, isn't it?
Right, 5220. Affirm, set aside or vary any order or judgment made or given by the lower court. Refer any claim for issue or issue for determination by the lower court. Order a new trial or hearing. Make orders, interest, costs order.
I think 1 is there's also 52, the first subparagraph.
It has all the powers of the lower court, yes.
That's the bit I meant.
But,
And I'm thinking that if the President had decided that there was a fundamental change in circumstances, then he would have had the power to go on and decide what to do with the extant summons, having set aside the return order.
Yes.
But that then calls into question what evidence and information he would then have required.
Exactly. I don't believe he would have done it at that hearing,
Well,
in Isaac's motion.
no doubt there wouldn't even have been time
Yes.
Yes, to do it because it was being done in stages. And in June he dealt with A and B of paragraph 89. In July he dealt with C, and he never got to D, and would have been doing it probably today if this appeal hadn't
Yes.
supervened.
And by natural extension, if the court's thinking that it can go there, Isaac's mission, it would need further evidence, and this is probably the wrong court for that, and so it would have to be remitted.
Thank you.
thank you.
So I was going to go on to child's objections if the court wanted me to, and re-end Zimbabwe, and discretion, etc. And as we've ended up where we are, which is if the court does set it aside, the decision from the President, and says that the Hague, the end result being that the Hague application needs to be looked at again, then further information and evidence would have to be gained,
Give me-
and it would
give
be
me
a first
examples.
instance decision.
Such as?
Well, my own friend on behalf of the children mentioned a broader defence being put. No doubt there would be up-to-date information from America concerning the American judge, for example, what could be provided there. And my client would no doubt want to file up-to-date evidence concerning what he can provide the children going forward.
Right.
There is this aspect, which is just a little vignette from paragraph 46 of Riem Zimbabwe, which is Baroness Hale, page 19 internally, 19 electronically of the authorities bundle. When it talks about the discretion, because of course in a Hague case, paragraph 46 in the middle. Apologies for this being this version of this judgment taken off the internet, but it is correct. But the Hague process, of course, is has a defence been made out? If it has, then the court has a discretion to return or not.
Yes.
And her ladyship's talking about the exercise of discretion there in the centre of that paragraph. Once discretion comes into play, the court may have to consider the nature and strength of the child's objections, the extent to which they are authentically her own, or the product of the influence of the abducting parents, etc. And so that, in answer to your ladyship, is something that may come up for further information and evidence.
All right.
Because
Thank you.
that's not, it was touched on in the immigration appeal. It's not something that was really looked at. Can I just turn my back for a moment?
No. Thank you,
Anything
Mr.
else?
Gupta. You've been very clear. Mr. Little, do you follow?
Indeed, my lord, I do, thank you.
Thank you. Yes. Anything in reply? Mr. Hames, Mr. Ration, you can fight over who goes first.
I think, my lords, nothing for me unless there are any particular questions.
Thank you very much. Mr. Hames.
Justice, my lady, I think my lord, or Justice Peter Jackson, asked about whether the judge in America had even contemplated the children going into foster care. There are some passages in the early part of the judgment that deal with the judge's attitude
Yes.
to that.
We picked those up. There was, yes.
Thank you. And you seemed that she was really bewildered by the suggestion.
Yes, I'm surprised. I wasn't aware of having raised that issue. I think I suggested that it was quite understandable why she might have reached a conclusion about foster care, even as a matter of jurisdiction and then of merits. But there we are.
So be it. I mean, the only other matter I was going to raise is that the essential difficulty that the President found himself in in July was that despite making it clear that he did not want there to be even that small amount of time when the children go into the care, custody of their father, it's abundantly clear that from the moment they hit the tarmac on any of you, there is a period when, even on the American court order, they will. That leaves open a risk that the President contemplated and wanted to protect against. And there is therefore a fundamental change that protection no longer is there. Unless I can assist, that's all I had in reply.
No, thank you very much indeed. Well, thank you all. That obviously concludes the party submissions. We're very grateful to you all for the hard work both before and during today's hearing. We will be reserving our judgments. We will proceed with all haste and expedition as we can. We'll distribute judgments under embargo in the normal way for typographical corrections and any consequential matters. Are there any dates or events that we might not be aware of that we need to be aware of in the next few weeks or months? No, well, if that changes at any stage, will you please don't hesitate to communicate with the court. If we hit any unexpected delays, then we will try to do our best to keep you informed. Anything else you'd like to raise? Anything else?
No, thank you.
No, thank you all very much indeed.